how do you do your estate planning when your beneficiaries are all underage? Hi, Nancy Bovier here with Agapi and NEXsteps. So you finally decided to create your estate plan. That's great. Of course, I'm assuming that by now you understand that that is more than just creating a will. But now there's a few complications in your estate plan. The biggest one being that your beneficiaries are all either minor or dependent children. What do you do in that case? Well, that's what we're going to talk about this week. As most of you are aware, the law does not allow minor children to automatically inherit any kind of finance. They're not of age of majority and they are not able to make those decisions. That's why in your will, you make accommodation for guardians for your minor or dependent children, and you ensure that it is laid out very, very clearly what that looks like. Your guardian and your trustee can be the same person, but they might also be different people. Each of those areas have different responsibilities and different requirements. You may have a guardian who would be the best person for your children to grow up with, under their guidance, under their roof, with their oversight. But you may choose somebody else as the trustee because that person is more structured, more organized. You want them to be able to manage the finances. And in some cases, you may want to keep that managing of the finances separate from the trustee. If a testamentary trust is triggered by the will, then that means that your trustee, your executor, is going to have obligations for a very long time. They're going to have the responsibility of managing the funds that were left to the minor or dependent children. They're going to have to keep records. They're going to have to file returns. They're going to be responsible for staged payouts if that's how things have been structured. But there are other alternatives. Once upon a time, we all thought that trusts were for the rich and famous. They were out of reach for the average person. Well, things have changed. Things have changed not just in the realm of trusts being more approachable and more affordable for the average person, but also estate planning has largely changed, especially over the course of the last 70 years or so. Prior to the boomer generation, most people didn't have the opportunity to accumulate wealth. The typical family in those days, the husband was the breadwinner, the mother was the stay-at-home, take care of the children, take care of the house, and there was one income. There weren't the choices for so much expenditure on commercial products. There wasn't the accumulation. There wasn't the ability to accumulate things and assets or accumulate financial means. Those have happened more and more frequently, and especially in the age of the boomers. That's why they talk about the multi-billion-dollar transfer of wealth between the boomers and the next generations, because the boomers were truly the first generation that, by and large, did have that ability to accumulate so much wealth. So let's get back to the issue at hand. The issue at hand is that now this wealth has to pass on to your beneficiaries. But there are trusts available to manage the distribution, the care, the investment of the assets for the eventual distribution to these children. There's a lot of reasons why the testator might put guardrails on how the inheritance is going to be doled out. For instance, let's assume that all of the beneficiaries are of legal age. Let's assume that there are 3 children, and one of them has addiction issues. The parent may not want to disinherit that child that has the addiction issues, but they may want to also ensure that it is distributed in a way that does not enable that addictive behavior. So they may set up a trust or a staged distribution for that person. There may also be beneficiaries who are of age, but are still young enough that maybe they're not very responsible with their money. Again, you might want to have some staged payouts. Those can range from very simple estate planning issues to very complex, requiring the structure of a trust. I always recommend that people make sure that they are talking to the appropriate expert when they're setting these things up. You do need to talk to a lawyer who has experience in trusts and knows how to set things up. If you have a disabled adult child, there are various vehicles, such as a Henson trust, that can protect the inheritance for that child with that disability. There are different ways to do it, but you have to make sure that you get the right advice. Some people will set up the trust on their own, and it's not like you can't go online and find out how to do it. The problem is you don't understand the potential tax implications, the little differences that could deem it to be an invalid trust. Always make sure that you are getting the proper advice. So when you're structuring your estate plan, make sure that you get the proper financial planning advice. Make sure that you get the proper legal advice, and make sure that you have the proper tax advice. All of those pieces of the puzzle play together, and they play together nicely when they are planned for. I'm a certified executor advisor. I'm not going to give you the advice on the legal and the tax and the financial side, but what I will do is I will identify those gaps in your plan that you need to close to prevent bigger issues when the time comes to administer your estate. Check out the information on my website or reach out. I'm happy to help. And as always, I've got an article over on my website about this topic. The link is in the description box. I invite you to hop over. Please read a little bit more detail. If you have any questions, I'm always here if you wanted to reach out. Thanks very much for joining me this week. I look forward to sharing more with you next time. Bye for now.